Good morning, Mr. Florio. Two things. One is, as I understand it, the opposing party is relying on their brief, so you will be the only counsel arguing today. And I think the courtroom is cleared, so you may proceed.
Thank you, Your Honor. May it please the Court, Attorney David Florio for Juana Pagan. The issue in this case is simply the unauthorized practice of law. The lower court found that an agent who does not have a license to practice law can represent a litigant in court. Ms. Pagan has appealed. For the record...
Have any amicus weighed in on this? Are they aware of it, like the Mass Bar Association, Boston Bar, any of the organizations?
The Worcester County Bar Association did file an amicus brief when the case was before the appeals court. They were going to refile it with this court. However, I believe they missed the deadline.
This seems to me to be a very substantial issue that the bar associations would be concerned with.
Mm-hmm. I believe so as well, and certainly the Worcester County Bar Association was informed. They were very concerned with it. They did hire counsel to file a brief. I do have a copy of the brief.
And this issue comes up with a great deal of frequency, even when I was there, in the housing court, right?
Yes, it does, Your Honor. And
what do you do with these landlords that own, or companies, corporations that own multiple housing units? Are they supposed to appear themselves or hire a lawyer?
Well, I take it corporations must be represented by counsel.
The Varney case makes that extremely clear, and there's no
Okay, so we can eliminate all corporate and real estate trusts, and all those would have to have lawyers, correct?
Yes, they would, because they're not actual human beings. They have to be represented by agents, and therefore that any agent that represents a principal in court must have a license to practice
law. So we're only
law.
dealing with cases where the owners are actual human beings who are using agents.
That is correct, Your Honor. Collection agencies, things of that nature.
Could I ask you, following up on Justice Greeney's first question, I mean, you certainly have brought to our attention what strikes me as a very significant issue of potentially very broad impact in the housing court, in landlord-tenant, the real world in general, and worthy of our looking into it and grappling with it. But it seems to me your client's case is moot, except for your claim that you had counterclaims against LAS Collection Management, or Ms., I forget what her name was, arising out of her unauthorized practice. And I'm a little puzzled by that, because I can understand why your concerns about unauthorized practice could lead to the dismissal of the complaint, and if you're right on that theory, should have led to the dismissal of the complaint. But how does it lead to a counterclaim that keeps this case alive? And just to tell you where my mind is headed, why shouldn't this be committed to, something in the Rules Committee or something where we could just get broader input from the housing court, from bar associations, from, tenants' rights advocates, from landlords' advocates, and make sure we come to a legally correct and pragmatic solution to this issue?
Well, to answer the first part, which is this properly before the court, I believe, yes, it is. What had happened was that the High Rock Group, which is the landlord, I believe it's a DBA for someone named Mark Schumacher, who owns the property, I think as tenants by the entirety with his wife at the time, hired LAS Collection Management. They filed a complaint, an equitable complaint in the housing court that had as the caption of the case, High Rock Group versus Juana Pagan. Then under High Rock Group, where there's supposed to be an address, put care of LAS Collection Management. The complaint was then signed by LAS Collection Management, a.k.a. Lori Spalding.
As agent?
As agent, in parentheses. So clearly no BBO number. Clearly this wasn't an attorney. Yeah. Counterclaims were then filed, along with a motion to dismiss, essentially saying that this is neither party nor counsel. There's no BBO number. This case needs to be dismissed for that reason, brought by an attorney or by the actual owner. those counterclaims, well, I should say after the motion to dismiss was granted,
Denied.
I think
Denied.
or denied, I'm sorry. The court, I believe because of its finding that LAS Collection Management / Lori Spalding was in fact acting pro se, then the housing court on its own changed the parties in the case, or I should say the plaintiff in the case, from High Rock Group to LAS Collection Management, effectively dismissing, or not even effectively, just dismissing all the counterclaims. And I think that's the problem that the appeals court had in hearing this case, that they weren't quite recognizing that, and that's why I'm glad this
Maybe you
court...
can clarify for me. I don't quite understand. Precisely what were each of the counterclaims?
The counterclaims, well, first of all of them encompassed under 93A, Consumer Protection Statute. They
Well,
involved
as I
abuse of
understand it, there were
process.
claims for monetary damages and injunctive relief, correct?
Yes,
Against
quiet
High Rock?
enjoyment.
You mean-
Well, that's who they were filed, and that was one
Okay.
of the problems I faced.
I
Is I'm
think I
filing
understand
in,
now what
So
you
what
mean.
you're
I'm
saying-
filing in counterclaim, and I don't know who I'm suing. I guess is what
What
happened
you're
after the
saying
motion
is
to dismiss.
the case may be moot as to the plaintiff.
Well, it's moot as
the
to the
injunction.
injunctive relief.
Injunction, but
Yes.
your counterclaims were wrongfully dismissed,
Correct, Your
And
Honor.
High Rock was wrongfully
Substituted.
substituted.
Correct. For
So-
example, if I was to file a motion to attach real estate, I would be attaching it against,
So they
I'm
should
not
be
sure.
your counterclaim should be reinstated, and there should be a trial on it, and is what you want,
Correct.
or a hearing, whatever, and there should be a ruling that loss collection, whatever it is, can't participate
Correct, Your Honor. They should be
because they're not
enjoined.
lawyers.
Correct, Your Honor. That's precisely what
But
I'm
going
saying.
back to Judge Sossman's point, my point, it's a pretty big issue, and we don't have much on it.
Your Honor, I actually believe it's a very simple issue. I think the law is extremely clear on this matter.
But if we make a ruling that the plaintiff can't participate in the hearing, wouldn't that affect so many other hearings that
No.
proceed in the housing
Oh,
court?
the plaintiff can participate in the hearing.
Just the
as a
collect-
defendant in counterclaim. They just
but
have
they
to
just
hire
can't
an
use
attorney
law.
or
Right,
represent
but I'm
themselves.
saying, but won't that affect so many other cases in the housing court?
Well,
That-
yeah.
Well, I think rightfully so. If that's what's going on, that's precisely what should happen.
But I think
It's-
that's what
it's not
Justice
a- it's-
Graney's initial question was
It's not,
directed
it's
at.
not as if, it's not as if this issue, to be frank, has not been pretty well raised by the bar, not in amicus briefs here, but the notion of the unauthorized practice of law is not exactly a new, different, or other question when it comes to these kinds of practices, correct?
No, Your Honor, I believe it's well settled. And I think the ruling of the lower court is completely opposite of what the well-settled law is. The law is very clear that if someone hires
It
an
seems to be
agent...
well settled, because to allow it would more or less open up Pandora's box.
It does. I would suggest that there's no need for the Board of Bar Overseers, no need for character and fitness tests, no need for bar dues. All the canons of ethics would be unnecessary because you could hire an agent to represent you in court that isn't licensed to practice law. That entire regulation of the legal profession would be over. And
How does it affect debt collection agencies and something other than landlord-tenant if they're just trying to collect the
Isn't the
debt?
debt assigned?
Well, if it's not assigned,
well, if the debt's
what
not
if the
assigned,
owner of the debt says to the agency, "You collect it for me. If you can get it, then you get
Right.
half," or whatever the rules are. Is that
they
okay?
they can still try to collect the debt, but if they do file a complaint in court, then of course they do need to hire an attorney to do so, unless they are the owner
How
of
do you
that.
collect a debt without filing a complaint?
You make a phone call and ask to have them pay it.
Oh,
Whether
okay.
that actually
so the
happens
minute
is
the debt
another
collection
question.
agency goes to small claims court and fills out a form that they're in trouble.
Well, small claims court is different, and that's where the
Right.
Varney case came in. The
All right.
Varney case
okay,
took
so
the general...
small claims is exempted.
Correct.
It did make an exception. The Varney case
Okay.
made an exception for small claims court.
All right.
All right, now if let's assume for a moment the rent, let's assume this is a case about non-payment of rent, and the rental payments had been assigned by the landlord to this agency, this agency being a sole proprietorship. Could the agency then send the proprietor in to represent herself in this case in the collection of that debt?
It depends. There's some clear cases on the fact that if the purpose behind the assignment is somewhat subterfuge for the idea of avoiding the licensing of the practice of law, the answer is clearly no. If it is assigned and it's bona fide, then it's possible that that's
Well, then she would be the real party in interest.
She'd be the owner of the debt at that point, if it's legitimate.
Yes, but there have been situations where those assignments have just been a piece of paper for the whole idea just to avoid having to hire an attorney, and that clearly is clear black letter law. No, that's not proper. And also, that's not the facts of this case. That's a case that I wish I was before the court on to argue, as opposed to something as straightforward as this one.
I take it, and this, I don't know how we get you out of this conundrum, but in addition to the monetary damages that are not moot, as I understand it, you've also asked for attorney's fees, and the caption of your brief is Highlock Group care of Lass Collection, so I take it you would like the attorney's fees from Highlock.
Correct, Your Honor. A few theories for the attorney's fees. One would be, obviously, I believe it's a contempt of court to practice in court without a license to practice law, but also as far as monetary damages.
Was a contempt action brought?
No contempt action was brought. It was just a motion to dismiss.
No adjudication of contempt has been made.
Mm-hmm.
The judge below in the housing court thought they could do this.
Yes.
So I don't think that theory is going to fly.
No, but also I brought a claim under 93A, the Consumer Protection Statute, that I do believe it's an unfair and deceptive act or practice to hire someone who isn't licensed to practice law.
But you need a finder of fact to figure out all that, and we don't have that yet either, do we?
Correct, Your
Oh,
Honor.
and you're happy to
I
get
may
it
have been a
signed.
little presumptuous.
No, but
You may be jumping ahead of yourself on that.
Mm-hmm.
But good try.
Thank you, Your Honor. Certainly this case has been quite a bit of work bringing it all the way to
and
this
possibly a winning try.
Yeah, you may,
court. I would hope so.
You got a big issue here. You may go in the books with a big issue.
Anything else?
If there's
Mr.
no
Farley?
further questions, Your Honor, I'll stand on my brief.
Thank you.
Thank you, Your Honor.
Sure. Can we have a short break?
Cases.